In this issue of ICC in Focus, we talked to Fatou Bensouda, the prosecutor at the International Criminal Court. The prosecutor decides on opening investigations, investigates, and prosecutes those charged with crimes under the court's jurisdiction. What does justice mean to your office? What would you say constitutes a fair trial?
The ICC's fundamental role is simple: to ensure that prosecutions will be brought for the world's worst crimes in fairness and in strict accordance with the law, and by so doing, to prevent future crimes. In doing so, justice imposes a very high burden on the prosecution to prove guilt beyond reasonable doubt. Indeed, there is no higher standard of proof in any national or international justice system. This standard is deliberately high because the consequence of a conviction, including the deprivation of a person's liberty, is so significant. The prosecution is a party to the judicial system. Of course, it strives to prove its cases. Likewise, the defense strives to secure acquittals. Victims provide their viewpoints, and ultimately, the judges decide. This is justice and the Rome system at work. The ICC is a new court, but it is permanent. In the decades and centuries to come, there will be more convictions and more acquittals. This is how fair justice works and how it should work. There are various facets to justice: what happens in the courtroom, but also the impact of the ICC cannot be underestimated. The court has a preventative role and a capacity to diffuse potentially tense situations that could lead to violence by setting a clear line of accountability. For example, the former United Nations Special Representative of the Secretary General for Children in Armed Conflict observed that even before the Lubanga case was concluded, armies around the world were changing their rules so as not to recruit children to fight wars. In the case of the Lord's Resistance Army, LRA, in Uganda, for example, International Criminal Court arrest warrants against Joseph Kony and his top commanders are widely acknowledged to have played an important role in bringing them to the negotiating table in the Juba peace process. Kenya has just emerged from an election very different from the previous one, and history, only history, will judge the impact this court's action may have had in contributing to peaceful elections there. My office will continue to work hard to ensure justice for victims, accountability for perpetrators, and to contribute to the prevention of future crimes.
The ICC is currently involved in 8 situations. When investigating crimes in these 8 situations, what is the main purpose of the Office of the Prosecutor?
The Office of the Prosecutor is currently investigating and prosecuting alleged crimes under the jurisdiction of the court in the Democratic Republic of Congo, Uganda, Central African Republic, Darfur region of Sudan, Kenya, Libya, Cote d'Ivoire, and Mali. The court is complementary to national proceedings, and my office has intervened because the states concerned are either unwilling or unable to genuinely investigate and prosecute these crimes themselves. In investigating, the policy of the Office of the Prosecutor is to identify, based on the evidence, those most responsible for the most serious crimes of concern to the international community. In each of these cases, we follow the evidence, and it is on this basis that the office determines which individuals will be prosecuted.
Kenya is 1 out of 8 situations where crimes committed have been investigated by your office. Could you tell us how the Kenyan situation is similar or different from the 7 other situations?
There are different ways my office can initiate an investigation in any particular situation. Uganda, the Democratic Republic of Congo, Central African Republic, and Mali all referred the situations in their countries to the Office of the Prosecutor. The situations in Darfur, Sudan, and Libya, where the court had no jurisdiction because they have not ratified the statute, were referred by the United Nations Security Council to ensure justice for the victims of crimes allegedly committed on those territories. Côte d'Ivoire, even though at the time not a state party to the Rome Statute, accepted jurisdiction of the International Criminal Court and requested the court's intervention. Kenya is the first case where an investigation was opened on the basis of the prosecutor's own proprio motu powers, authorized by the judges of the ICC. The prosecutor intervened following consultation with Kenyan leaders, an agreement that impunity was not an option following the post-election violence. In all these cases, the office is investigating and prosecuting alleged crimes under the jurisdiction of the court: genocide, crimes against humanity, and war crimes.
Could you remind us how Kenyan post-election violence came to be investigated by the ICC?
The preamble of the Rome Statute states that the primary responsibility for the investigation and prosecution of the most serious crimes of international concern lies with states. The ICC only intervenes in a situation when a state is unable or unwilling to genuinely investigate or prosecute the alleged crimes. On 3rd July 2009, the previous prosecutor of the ICC met with a high-level delegation of Kenyan government officials in The Hague. The delegation informed the prosecutor about the steps they planned to follow to investigate and prosecute the post-election violence in Kenya. The Kenyan officials and the prosecutor, my predecessor, agreed that impunity should not be an option, and that to prevent new violence in the 2012 elections, it was necessary to prosecute those responsible for the crimes committed during the post-election violence. The Kenyan delegation committed to provide the prosecutor, my predecessor, with a status update by the end of September of 2009. However, despite several attempts in 2009, Kenya's parliament did not manage to pass the legislation required to establish a special tribunal. So on the 5th November 2009, my predecessor, the prosecutor, met with President Mwai Kibaki and Prime Minister Raila Odinga in Nairobi. He informed them that since all the statutory criteria were fulfilled, he would be seeking authorization from the chamber to proceed with an investigation into the situation in Kenya in relation to the post-election violence of 2007-2008. At that time, the President and Prime Minister issued a joint statement where they recalled their constructive meeting with the prosecutor of the ICC, my predecessor, and they stated that Kenya was fully committed to cooperating with the ICC within the framework of the Rome Statute. Since then, the government of Kenya has not demonstrated to the judges of the ICC that it is actually investigating or prosecuting the three accused for the conduct that is the subject matter of their cases at the ICC. On the 31st of March 2011, the government of Kenya filed a challenge to the admissibility of the Kenya cases before the court. The pretrial chamber dismissed that challenge on the grounds that the government's application had, and I'm quoting, failed to provide the chamber with any information as to the conduct, the crimes, or the incidents for which the three suspects were being investigated or questioned. This decision by the pretrial chamber was also upheld by the appeals chamber. The judicial process is now in motion at the ICC. Justice must run its course.
What are the crimes for which Mr. Ruto and Mr. Sang are facing a trial, and in which specific locations were those crimes committed?
Mr. Ruto and Mr. Sang are charged with the crimes against humanity of murder, deportation, forcible transfer, and persecution. The alleged crimes are believed to have been committed in locations including Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills in the Uasin Gishu and Nandi districts.
What evidence is your office going to present to the judges during the trial?
In due course, before the start of the trial, we will file a public version of our pre-trial brief, which lays out our case against the two accused and indicates what evidence we will rely on to prove the charges.
Some witnesses initially called by the Office of the Prosecutor were dismissed. Some have decided not to testify, while others were found to be giving false testimony. How is the office planning to overcome such challenges?
First of all, many of these witnesses have gone to great lengths to risk their lives and the lives of their relatives to support our investigations and prosecutions. These are people of immense moral courage who want to see justice done in Kenya. Efforts to find out who our witnesses are have continued unabated as the trial dates draw closer. Relatives of witnesses have been approached to disclose the whereabouts of witnesses or those perceived to be our witnesses. Incentives, including bribes, have been offered, and in some cases, threats and intimidations have been used to solicit information about our witnesses. The security and safety of witnesses is a priority for us, and this explains our request to the Chamber for delayed disclosure until the Witness Protection Unit has taken adequate protection measures, including removing the witnesses from Kenya.
There are allegations that some of the prosecution's witnesses have been intimidated. Is your office planning to take action against those that may be responsible for such threats?
Those who tamper with witnesses are very discreet and go to great lengths to hide their identities. We are monitoring the situation closely and continuing to gather as much information as possible related to incidents involving our witnesses and the pressures our witnesses are encountering. We will take action based on the evidence.
How long will Mr. Ruto and Mr. Sang's trial take?
The length of my case against Mr. Ruto and Mr. Sang will depend on several factors, in particular, the schedule that the judges set for the trial hearings.
How many witnesses does the prosecution intend to call? Experts, insiders, witnesses to crimes?
The prosecution intends to call over 30 witnesses, which includes witnesses to the crimes as well as expert witnesses.
How strong is your case?
Assessing the evidence of the case is not a matter for public speculation. It is a judicial matter. As required by the law, the prosecution will present its case before the judges, and ultimately, they will independently decide. My office remains committed to justice for the victims of the post-election violence, the men, women, and children who were killed, injured, and forcibly displaced from their homes in 2007-2008 must not be forgotten.
Will Kenyans get justice?
The ICC process in Kenya was initiated to hold perpetrators, those who allegedly are most responsible for the most serious crimes, accountable, and to ensure justice for the victims, those who were killed, raped, and forcibly displaced from their homes. Of course, there are various facets to justice. Convictions form part of it, but we must not be short-sighted by underestimating the preventative impact of the court either. Kenya has just emerged from an election very different from the previous one, and history, only history, will judge the impact that the court's actions may have had in contributing to peaceful elections there. The Office of the Prosecutor remains committed to doing all we can to pursue justice for the victims of the 2007-2008 post-election violence. As required by the law, the cases will be presented before the judges when the time comes, and ultimately, they, the judges, will independently decide. Now that this judicial process has begun, justice must run its course.